to quote one of my dear mentors from the South, that seems to be that we went around the block the long way to get where we need to be. The word restroom really needs to be in the legislation if there's any legislation. Quite frankly, you don't want to have trial lawyers litigating over whether the ladies' room is a place where seeing somebody unclothed is unavoidable or not unavoidable. The word restroom is clearly needs to be inserted into any type of legislation, and the carve-out is important, and I would encourage the committee to continue to use those carve-outs. Employees have a very high expectation of privacy in certain areas, such as dressing rooms, locker rooms, and restrooms. I handled a case a few years ago up in my home state of Massachusetts where a female employee had brought a Title VII lawsuit alleging hostile work environment under Title VII based on the fact that there was a hole in the ladies' room which was about knee-high. It was not put there intentionally, but it still allowed, if someone bent down, the opportunity to view into the restroom, and she felt that that was significant enough to her to go ahead and rest part of her federal lawsuit upon it. Again, you need to be aware of the fact that employees do find certain areas of privacy very important. Finally, the issue of notification. There's some issue here about what to do with a individual who might be transitioning from one gender to another, and that's not easy. I understand that the committee will be challenged by if it addresses that. We do need to have some sensitivity to the employer. At what point does the employer need to make modifications to their workroom for individuals who might be transitioning? If the person gives notice on Monday, does the employer need to then allow them to use the restroom of the opposite sex on Tuesday? Finally, I would encourage the committee to consider jurisdiction if there is any type of legislation that is passed. With all due respect to the state judiciaries, federal courts are far more equipped to handle discrimination suits. They're better funded, the judges see them more often, and they process through the court system much more rapidly than at the state level. And for that reason, I would encourage that the committee consider the jurisdiction of the federal courts to be exclusive if there's any type of legislation. And finally, prevailing costs or costs and fees to a prevailing party is also important. Employers are getting hammered by legal fees and costs to fight frivolous lawsuits, and they need to have some sort of mechanism to be able to recoup some of those costs.
Ms. Miller, thank you very much. I appreciate it. Dr. Hendricks, welcome to the subcommittee.
Thank you very much. Mr. Chairman and members of the subcommittee, my name is Bill Hendricks, and I'm a product stewardship specialist for the Dow Chemical Company, and I've worked for them for 19 years. In addition to my role as a product stewardship specialist, I also serve as the company's Gays, Lesbians, and Allies at Dow, or the GLAD network. It's an affinity group advocating for gay, lesbian, bisexual, and transgender and allied employees within the company. GLAD is one of the 6 employee networks at Dow, all working towards promoting an increasingly diverse and inclusive workplace. Dow thanks the subcommittee for holding this hearing to examine the discrimination that many transgender Americans face in their workplace. First, let me provide just a little bit of background on Dow. Dow was founded 110 years ago in Midland, Michigan. Our small-town Midwestern roots have encouraged us to establish enduring core values of integrity and respect for people. It is these values that form the very heart of our approach to diversity and inclusion. At Dow, we serve customers in 160 countries, and we have about 43,000 employees. Clearly, diversity underpins our workforce, our culture, and indeed our very business model. We know that it is our human element that is key to our success. As a result, we know that creating a respectful, inclusive working environment is not only a matter of fairness and equality, but is one of critical economic and business importance. With a shrinking talent pool, particularly in the sciences and engineering, it is essential for us to actively include everyone to ensure that we attract and retain the very best talent that's available to us. As an industrial business-to-business supplier with virtually no consumer marketing, we must work even harder to have an identifiable employer brand. When we discuss LGBT workplace policies, we do so knowing that these policies give us an advantage. Because we don't have major offices or facilities in the metropolitan areas of the U.S., our LGBT employees often have more protection from discrimination under Dow's policies than they do in the laws of their state or locality. Specifically, our LGBT policies have been good for our workplace for two main reasons. Number one, retention of our LGBT employees because they know that they can perform their job without fear of repercussion and therefore have more reason to be committed to the company. And number two, better recruitment of allies and younger workers who often use things like employee benefits such as our transgender policies or our flexible work hours as a litmus test for prospective employers. For Dow, like most companies, the offering of benefits to LGBT employees has been a result of a multi-stage journey. We first instituted sexual orientation in our employee non-discrimination policies in 2000. We then added parity for domestic partner benefits in 2002, and we added protection based on gender identity in 2005. Of special note, we have implemented this globally for all 160 countries that we do business in. When comparing our company to other Fortune 500, Dow is one of the nearly 300 that currently offer protection for employees based on gender identity. Loss of talent comes at a very significant cost to employers, many of whom, like Dow, will suffer from shortages of qualified workers as baby boomers retire. For our workplace transgender policy, we leveraged a policy developed by the Human Rights Campaign and then modified it slightly for our specific workplace conditions. This policy strongly emphasizes the mutual respect and good communication between the transitioning employee and his or her supervisor. Communication to the transitioning employee's work group is also critical. For example, working with the transitioning employee, training seminars can be created to prepare coworkers. Our policy also addresses questions such as transitioning name change, updating company databases, and offering support for other legal documents such as passports that are required for work. As I have mentioned, it has been a journey for my company. On the whole, our program has gone remarkably well. We have had one employee transition to the workplace since 2005 and utilize these policies. As expected, coworkers have had a few questions and concerns, but our company has been able to address them and to ensure that the workplace remains very respectful and productive. In discussions with the transitioning employee, she felt that most of her coworkers were quite accepting and supporting. Overall, we have achieved a positive reception of our transgender policy, both internally and externally. Internally, because of our strong commitment to our Human Elements campaign policies, very little negative notice was taken of the inclusion on gender identity. This is just one more diversity factor within a comprehensive program that our company offers. Dow appreciates the chance to share our views and applauds the committee's work to gather more information on gender identity within the workplace. And we welcome any further questions you may have.
Thank you, Dr. Hendricks. We appreciate your perspective very much. Thank you for being here. Mr. Levy, welcome to the subcommittee.
Mr. Chairman and members of the committee, thank you for allowing me to testify today. You are hearing stories of painful experiences in the workplace. You're being asked to make a moral...
I'm sorry, Mr. Levy, would you pull the microphone a little closer to you? I think it's on, but it's a little muffled.
You are hearing stories of painful experiences in the workplace.
Is it on? Is your light on? Yeah.
It is on.
Okay. We won't take this from your time either, even though you didn't go to Cornell. We'll let you.
All right.
Okay.
You are being asked to make a moral judgment about the treatment of transgendered persons in the workplace. You are being asked to make the judgment that it is immoral for employers to refuse to accommodate a person's belief that he or she is a member of the sex that is opposite their anatomical sex. What you have not heard is that some employers have deeply held religious beliefs about these issues. Other employers do not have a ready ability to be able to accommodate a transgendered employee without violating the rights of other employees or members of the public when it comes to the use of restrooms. And unless an employee specifically requests an accommodation for his or her belief that he or she is a member of the opposite sex, an employer has no means of knowing the employee's views. Most transgender anti